Ed, let's go. All right. Ready to go? What did you say? What did you? All right. Okay, I call the code board into order now, and be sure your cell phones are cut off, shut off, stun gun, whatever. Okay. The city desires to accommodate persons with disabilities. Accordingly, any physically handicapped person pursuant to Chapter 286.26 Florida statutes should at least 48 hours prior to the meeting submit a written request to the chairperson that the physically handicapped person desires to attend the meeting. Any person who decides to appeal any decision of the Code Enforcement Board with respect to any matter considered at this meeting will need a record of the proceedings, and for such purpose may need to ensure that a verbatim record of the proceedings is made, which record includes the testimony and evidence upon which the appeal is to be based. Any person or defendant who requests to review or object to any exhibits presented to the Code Enforcement Board by the City of Titusville prior to submission to the Code Enforcement Board must stand and state their request to review the exhibits prior to review by the Board at the time their case or agenda item comes before the Board for hearing. Any person found to be in violation of the City of Titusville Code of Ordinances and given a time frame in which to comply shall, upon compliance, be responsible for contacting the Code Enforcement Supervisor for an inspection to verify said compliance. The violation will not be considered to be in compliance until the Code Enforcement Supervisor is notified and confirms or verifies compliance. And we have a quorum. Would you please stand for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right. Ms. Fisher, would you like to swear in the witnesses, please?
Please raise your right hand if you intend to give any testimony. Anyone who's going to give testimony, please raise your right hand. Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth?
Thank you. All right, everybody had a chance to look at the minutes from last month. Any changes, corrections?
I'll make a motion to approve the minutes of the meeting of Monday, October 8th.
Second.
Motion by Joe, a second by Ed to accept the approval of the minutes of October 8th. Any questions? Roll call vote, please.
Member Ozon?
Yes.
Member Richardson?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Herman?
Yes.
Chairman Bell?
Yes, motion carried. All right, Ms. Chelsea, you're up.
Good afternoon.
Good afternoon.
Under old business, the first item on your agenda is the property is case number 18-63, which we have noticed for the property located at either 12 or 20 North Washington Ave. And the owner of the property is James South, and he is also here to address the board after the city gives its presentation. As a reminder, this case was previously presented to the Code Enforcement Board in April, and at that time, the board issued a continuation of this case to allow the owner for, I think it was 6 months at that time, to correct the violation and ordered the property to be brought into compliance by Friday. And as of last week, the owner of the property had submitted an application for the demolition permit of the billboard that is located on the property that is the subject of this code enforcement violation. The billboard demolition permit was received, but it's my understanding that it has not been issued. I've invited the building official to provide testimony regarding the demolition permit and progress on this particular case. I'd like to invite up Mr. Gary Stepalovich at this time. Mr. Stepalovich, have you reviewed the property located at 20 North Washington to determine if there is a demolition permit on file to remove the billboard that is the subject of this particular case?
Yes, I have.
And is there a demolition permit that has been issued for this property?
No, there has not.
What's the status?
The status is it's still under review from the building department.
Do you have any further comment regarding the demolition permit application or process? Or does the board have any question regarding this?
May I ask when was the application submitted?
The application was submitted on November 6th, and today is the 12th, so we're within a week's time. I believe we're very close to actually approving the application.
For purpose of reminding the board of what your previous order stated, in April, the board determined that the defendant was given until 9 a.m. on Friday, November 9th to correct the violation, and that requires complete removal of the billboard as it stands on the property. Mr. Stepalovich, has that billboard been removed?
No, it has not.
Again, I have the owner of the property here to provide testimony. If the board has any particular questions of staff, now would be the appropriate time to ask.
Do you know how much
Okay.
longer it will take before the planning department comes to a conclusion on its permit?
We will probably be either today or tomorrow through the approval process, complete the approval process. And that'll just, at that point, the applicant will be notified to come pick up the permit
Okay.
and pay for it.
If it had been approved, that does not eliminate the violation, does it?
No, sir?
Okay.
If it's not approved, what remedy does he have since it was put up in violation anyway?
That's
That's out of
something that you need to
curiosity.
speak with legal
Just out
about.
of curiosity.
I'm sorry, could you repeat the
I
question?
just said, if it's not approved, what remedy does he have since it was already in violation when it was put up? And that's a question out of curiosity.
I would
more
add
so.
to the testimony that Mr. Hauk phoned me prior to this code board meeting to indicate that he thought he would need additional time and that he planned to come to this board and explain why. And in that phone call, I expressed to him that a demolition permit is required for the process of removing that billboard. So that instruction was given to the owner in early October, and after that time, he proceeded to apply for that permit on November 6th. So as far as the timeline and the requirements, that's the history, a short history of what has happened, but I'm not sure if that answers your question or not.
No, it's kind of a different question. And like I said, it was, because it was put up in violation, it already is in violation. If they're reviewing it for demolition, what would happen if they don't give him a permit? What remedy would he have?
I don't know why the building department would not issue the permit unless the application was deficient, but that's not part of the scope of what you're looking at. You're looking at whether or not the property has been brought into compliance, and compliance is achieved by going through the proper procedure through the building department, again, separate from what you look at. He's here to
Okay.
provide, some narration so you understand where the billboard permit sits as of right now with the city of Titusville. However, the property is still in violation as you reviewed it in April, where the billboard has not been removed.
Thank you.
In April, was that the board hearing? Was that the initial hearing or the compliance hearing?
That was the initial hearing.
Okay.
In April 2018.
So this is the second time this case has been before the board?
That's correct. At
Okay.
that initial hearing, Mr. Hauk was present and requested additional time, which this board granted at that hearing.
Okay.
So the initial evidence was presented in April 2018 regarding the photographs and the testimony, the building department's position, as well as a stop work order that was taken on November 11th, 2017. As a reminder, this billboard was repaired as a result of being destroyed in the last hurricane. Are there any further questions of staff?
So, from the way I understand what you were saying, Chelsea, is that the owner of the billboard was notified in October that he needed to get a permit, and he didn't actually request that permit until November. Is that what you were saying?
It was a reminder because October a year ago, that owner was informed of the process, the city's requirements for permits for demolition, removal, and installation of that billboard.
So I guess the situation is that there's been a tremendous amount of time to get that permit, that demolition permit, and it hasn't been provided.
Yes, because the city did initiate this case a year ago. However, it was not presented to the board until April. That's the history of the case, yes.
Was your case whether it's taken a long time to process a demolition permit, or whether it was a
Well,
long
it's-
time before he applied for it?
It seems that we're saying that
I mean, I know.
there hasn't been enough time to get this permit going, and it's been plenty of time.
Right.
If there are no further questions, I'll turn it over to the owner of the property to speak to the board. Thank you.
Afternoon, ladies and gentlemen.
Afternoon.
Last thing I want to do is come see you on Veterans Day, but here we are. It was a hurricane that got me into this mess. There was a viable piece of equipment and a billboard that was serviceable and had been repaired by me years prior. There was a 50-year lease on it, and it had gone into very disrepair. And the hurricane came along and bent it over, and somebody came around and took it down for safety's sake because it was leaning. We put it back up, as most people do, try to get back in business after a hurricane, to be told that we needed a permit. So I came in and we processed that. That was by my records, and I don't want to drag this to ever never, but this is my say, so I guess I got to be my own advocate here. October 17, 2017, I was talking with the city building department at that time. October the 16th, at 4:44 p.m., I forwarded an email to Lamar, who is my subcontractor who services and maintains the billboard. I just hung up with Titusville. They require 2 sets of sealed and construction plans and a site plan and a building application. That was October 2017. At that time, I was given the direction that if I had those things, we were green to go. It was a repair, a reposition of the board, as most of the damaged businesses in Titusville, to get back in business. Let's see here. We were hung up on wind loads, exactly what the wind loads were, because the structure that we put back up was a limited face. There was a limited structure, not a solid piece of plywood for a lot of wind load. It was more like a Venetian blind. It was more of a frame. So the wind loads were a difficulty in October. I advised them that I had surveys and some documents that would help get us to where we need. On the 23rd, 1 week later, I'm still after what we all wanted, was to get the I's dotted and the T's crossed. The building official has asked for, again, my email to Lamar. Number 1, a building permit application site plan, so they can see if we relocated the sign. 2, sets of sign drawings, engineers from the engineering end. And we went on through the month of October and the month of November, trying to get the engineer to do what we needed to finish the permit for the sign. Well, there had been a hurricane, so there was a whole lot of work to be done. So it was like pulling teeth to get that, but we were working on it. On December the 4th, Monday, I have a note at 3:20 p.m., again to Lamar. I just got a call from Titusville, ... They want the board down. So from October to December the 4th, I went from documenting a structure that I thought was viable to getting a call that that needed to come down. It was non-conforming. So we struck out on another track. At that point, the sign had been redone. as a lot of things in Titusville had been, thanks to Miss Irma. And I have damaged nerves, so my hands don't work too good. $24,000 in repair. April the 9th, I said, this is from an attorney that I was asking help from at Cobb and Cole. Just got off the phone with Assistant City Attorney, gave me a call and said that the board is non-conforming. So, quote, so frankly, it is kind of a no-brainer that they will find it is in violation. So I had no recourse per him. We made our appearances here before this esteemed body, and y'all gave me 6 months to recoup some of the monies that I'd had and to get things in order. I proceeded down that path, as I will document here. There was no need to file for a demolition permit at that time, in my opinion, because I had 6 months. We investigated trying to move it, take it down, put it up somewhere else. That didn't work. The contractor that I was referred to that works for Lamar, I was given his phone number, in September. Does anybody recall what happened in October of 2018? We had another hurricane. Called Michael, went through the north part, went through the panhandle. We had federal money, we had state money, we had insurance money. Guess where the contractor went? To the panhandle. And is still there. I have talked to him on the phone. He is out of the state, and he is making bacon. And to get him back would mean that I would have to outbid the state, the federal government, and the insurance company. I have not gotten the structure down because it's 40-foot poles that weigh 1,000 pounds. I could go out there with a chainsaw. I'm not sure which way they'd fall. There's a business that I do not own at 12 North Washington. 20 North Washington is what we're discussing, just for the record. So I have chosen not to get a novice or somebody that's ill-prepared or doesn't have the equipment to deal with the torquey 40-foot pole that weighs 1,000 pounds in multiple successions to get it down. And I have a picture in my phone here of a city truck that was parked there having lunch, so he would be in jeopardy too. What I have done, ladies and gentlemen, is I have not sat on my keister. I've shown you that I've been working on this since we met, that I had a plan that would have worked. I didn't know it would take a week to get a permit to take a board down after the city telling me it would have to come down last December. I have a permit that was filed. I have the number. You've had testimony that that's working. That's one thing I've done. Another thing I've done is I've gone to DOT. DOT is another person that gets a piece of your skin when you have a billboard. They require a license. It's a metal plate, a la a license tag like your car, metal plate. It has been removed. So it is no longer a DOT approved sign. I have done all that I could to make the sign not a sign. There is no signage on it. The billboard, the copy is down. The permit's been filed. The plates have been removed. And I need the proper people and equipment to take it down. I will get you that. And I will do it as quickly as I want to, because regardless of how friendly we are, I really don't like driving all the way down here and messing up your afternoon and messing up my afternoon and talking to those friendly people on I-95. Most of it by sign language. There's my check from Lamar. It's for $2,000 for 6 months. So there's certainly not a physical reason to have the board and endure the pain that we're doing. What I anticipated when I did that was a 10 or 20 or 50-year run as it had been previously. I guess at this point, I will shut up and answer any questions you have.
I got a question for you. Is that a wood structure?
I'm sorry?
Is that a wooden structure? You said you got two 40-foot poles there, telephone poles. Is the rest of it wooden?
May I? See, I'm not very legal. I was going to hand you that. That would have been
That's
real
okay.
cool.
That's his evidence, Mr. President.
That's Titus Fields.
The code enforcement officer, Frank Lewis, submitted that. I believe that it's date stamped for the date that he took that photo.
Okay, thank you.
Mr. Hawk, sir,
Sir,
why did it seem that it took so long for you to submit the application for what's that? Demolition permit? I believe it was said it was submitted on the 6th of this month, am I correct?
Correct.
And last meeting, we gave you 6 months, I believe.
correct?
May I ask why it took so long to submit the application? I mean, I have no idea how long it takes the city to approve an application, and they still haven't approved it even though you submitted it on the 6th. So I have no idea what the time frame is at, but may I ask why it took so long for you to submit the demolition permit application?
I did not see that as a significant situation. I thought the city would pat me on the back and lead me to the lot to take it down. I did not know it would take a week or more. He didn't say he'd have it in a week to process a demolition permit for a board that they deemed to have to come down last December. I would have that building permit standing before you today, except for the order of rule or what it was. That was last Tuesday. There were no holidays. It was submitted Tuesday on something that was already on the docket or on their radar screen. Is it their fault? No. Is it my fault? I don't think so.
Well, sir, if we go by the letter of the law here, you
I
have until the
understand.
9th to do this. And from my understanding from talking to the city, even if it had been approved, if the permit had been approved, but the sign was still up, then you're still in violation. Am I correct?
Yes, sir.
And I think I have explained and demonstrated what I have done. And by an act of God, the contractor's gone to take care of the panhandle. Now, I could tell you I'd have that down in 30 days, but I don't know that that's true. As all of you are well aware, there's another hurricane in the Atlantic with a plus 70% chance of developing in the next 5 days.
Yes, sir, we heard about that.
So, you know, time certain, I understand this is a letter of the law and this is a situation, and that's why I'm here addressing you today, to show you that I'm not reluctant in what I'm doing. I've done everything I can. I've taken the license off of it. I've got a building permit to demolish it in process, and I've taken the signage off of it. There's no income from it. I just need a situation that I can get it down, or we can just cross our fingers and hope somebody backs into it with a city truck.
Well, unless the city themselves decide that it would be okay with them to grant you more time, we're between a rock and a hard place here as far as, if that's the right interpretation. Because we are, you know, the cutoff date has passed, and I don't think we have any other choice but to still find you in violation, unless the city wants to, you know, do something different. That's just my opinion, of course. Other board members here, they can speak with their own minds.
I have been on that site since I have been on that site since 1976, personally. There was a beautiful rundown gas station, tire changing place on the corner, where now is a brand-new Cumberland Farms. I was going Cleveland, and that ain't the right place. I had spent significant dollars 3 times remodeling my property. How many years, how many decades did that endure with me making investments right across the street? I understand that Titusville wants that in compliance with that. I even tried to put a conversation about the building on the table at our last meeting, and that didn't go anywhere, to clean up the whole corner, if you will. That was before Cumberland Farms went in.
And the city deemed it not, well, they didn't approve it. Am I correct? They didn't approve the repairs that you'd made to the building?
No, they did.
They did approve?
They did, absolutely. When
Sir,
the-
I think that we're talking about October 2017, when your application for the permit for the sign was denied.
Okay.
I'm trying to figure out how we got here. Because
We got
I
here-
remember, if I remember correctly, you said that initially the billboard was destroyed by the hurricane. Am I correct?
Irma,
Okay, Irma. And you did some repairs to it, or some repairs was done to it
correct,
at that time?
correct.
Approved or disapproved by the city?
Approved.
I disagree.
December the 4th, I was called and told to take the board down. It was now non-conforming and non-approved. There would be no building permit.
And to be clear, the city did not approve a permit in 2017 for that sign. It was submitted but not approved. It was denied.
Okay, thank you.
It was paid for and submitted.
Since Hurricane Irma, it has been non-conforming.
There are no billboards permitted within this area, and so
In the
it was
downtown.
grandfathered in until it came. Got it.
The code provides that if it was did more than 50%,
If all the were, we probably have it.
I'm so sorry.
Okay, bring your hand right now.
I don't believe that is true. From the pictures that I've seen of the Panhandle, I think there is more damage there than will be done with in 30 days. I think 90 days I could get to, I will promise you that, unless this other hurricane comes in and makes something different. But y'all want a date specific, a date certain, and
Well, if it's going to take somewhere between 30 and 90 days to get the sign down, why did you leave the city only 6 days before you even applied for a permit? I don't understand why you waited so long to apply for the demolition permit when you had 6 months to do it.
because I wasn't going to use it. I have had experiences with municipalities before where a permit has been issued and a glitch happened, like a hurricane, And that permit time went out supposedly, and I get to repay the fee to re-up and resubmit and re-go through the program. I was within my time frame to have submitted it November the 6th. I was not outside my time frame. Was it later than maybe it could have been? Give you that. But it was not a requirement.
I'm looking at the order, and it says bring it into compliance by the date, not apply for the permit by the compliance date.
And where do you publish the timeframes for a building permit? So that I would know when to apply for that permit to be in compliance.
An approved building permit would be good for 6 months.
Where do you publish how long it will be in the building department so that I would know I needed to back that date up to get that done so that I would be in compliance?
The building permit application would tell you how long you have for the permit. The building department would be able to explain to you how long you have for your permit time frame. The building official sitting in between us is also the individual who you would have met with after that April meeting to identify those timeframes, as well as the city's code of ordinances says how long these permits last.
But how long would it take to get one?
Well, I keep going back to the order. The order from the April hearing says you have until 9 a.m. on November 9th to correct the violation. It doesn't say to pull your permit. It says to correct the violation.
And I have demonstrated that I have done everything within my power to do that.
But the question is, why did you wait till November 6th? I mean, you've had since April of this year to comply with that. I mean, technically, in any situation, it's going to take a while to get permits pulled anyway.
For demolition of a billboard?
I'm not a permit person, I'm not a building person, but you could have picked.
I had to go because this is personal to me. This is not, I promised you I'd have that done. You and told you I would do that. And as I walked out, I said, I don't like it, just as 50% of the people that voted in the select rule of the state has to be there, and that's how y'all proceed. That's what I said as I walked out. I was not thrilled because I'm a loser here. I get $24,000 and then we'll write it all off. Plus, I'm getting very frustrated with the ability to get it down. It's not something that I know how to do. Why did I wait till the 6th of November? Because I figured it was a one-day turnaround for a situation that there were no plans, no drawings, no calculations due to. We're going to take it down. We pulled a building permit to put it up, so all of that is on file. Now, it was not issued, but all of that is on file. So to take it down, why would it take more than Tuesday, Wednesday, Thursday, Friday, 4 days to issue that permit? And even if I had that permit, I didn't have the guy. I didn't have the crane or the, I don't even know what they use for a 40-foot pole. It's got to be a crane.
So the Lamar is the company that you hired to manage that billboard, right?
Lamar, yes, sir.
And you can't just hire any contractor. You have to have someone that is certified by Lamar to take it down?
I don't know. I didn't look at that in the contract. I have just gone through them because I didn't want to put some guy up there on a scaffolding that maybe didn't know what he was doing. So I went with somebody that is a professional, that has insurance, that has the documents and the knowledge and how to manage a sign.
All right, let me ask you a question.
Sir.
What do you want from us? And we'll discuss it, but we need to know what you're asking for and how long it's going to take and what you're going to do about it.
I know, and I haven't slept in 3 nights because I don't know what to ask you for. I was very sure until I saw that there's another hurricane coming, because 2 hurricanes have gotten me in this mix. The end of January is what I asked for. And if I do not get a firm commitment from Lamar, I will go outside of Lamar. I'll be going to the Yellow Pages, I guess, to see who's got a crane or can do. And it will come down, because it's of no use to me right now. It does not have any signage on it, does not have any license on it.
Okay, we'll back up one step further. You said you have a permit to put a new one up? Is that what you're saying too?
No, ma'am,
Okay, all right, well, I thought I
No.
heard that, but that's okay.
no.
Are you getting another permit to put one up?
I have asked to be able to use those materials somewhere. I'm German, I'm very frugal, and it's got to be efficient. So I wanted to take it down and be able to move it, re-erect it somewhere, or use it for a bulkhead. I have got nobody that wanted to touch it, which made me again think that I didn't have any recourse as to somebody to take it down. If I don't have anybody that wants to put it on a trailer, so I get it down. I got a 40-foot pole going through Titusville. I don't think I want that either. I know it is a very difficult situation for you all. It has not been easy for me. I have picked at and done everything I thought I could possibly do to make this happen.
Okay. Let us discuss it. But you still didn't give me an answer as to what you want. What do you want? Do you want us to give you some more time? Want to what?
Yes, please.
How much?
Like I said, if I can have through the end of January, I will either get firm commitments from them or go outside of them and look for somebody that could handle that construction, that situation. There are other sign companies, and I'm sure there are other subcontractors, and if not, we'll just get George with a chainsaw.
I'd like to ask the code board attorney for her input, please.
Well, if you were listening to my presentation, you have your first hearing where you take all your evidence and you find your violation and you calculate your time that you want to give to comply, and you set that date, and you need to stick with that date. And you have set a date for compliance, which is 6 months. And you did not set a date to pull a permit, you set a date to have the violation corrected. And this is a compliance hearing, which means all you are doing is taking evidence as to whether or not the property owner has brought the violation into compliance.
Excuse me, I think all of this discussion is missing the point. We've been through this. We made the point that there were 6 months to solve this problem and get the property in order. And I still don't understand why nothing was done for over 5 months, and you expect the city to to give you a permit to fill up the date.
No, sir, I documented several.
It doesn't matter what you documented. What you did was you submitted for a permit 6 days before you were due to have the structure removed.
Actually, 3 days, actually 3 days.
I think the question is he in compliance or is he not?
No, he's not.
He is, and
He's
we've
not.
seen from the evidence that we've all seen that he is out of compliance. That's the end of the situation.
Make a motion.
So y'all make a motion? Yeah, get a motion on the floor.
I make a motion that this is.
Second.
Second.
Motion, I move that the board issue its order correct.
No, you gotta get up the violation. So the second reading on the second page.
Motion for finding fact.
Yes, continue. 3A, yeah.
That the board issue the following findings of fact. move that the board issue the following finding of fact in case number 1863 relating to the defendant James D. Houck. The defendant continued to be in violation of the following sections of the Code of Ordinances of the City of Titusville on, what's the date?
12.
November 12th, 2018.
Name the violation.
The violation is Section 656, permit required billboard.
Second. Motion by Sandra, second by Mr. Herman. Any questions? Roll call vote, please.
Member Richardson?
No.
Member Herman?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes, violation.
Member Monis?
Yes.
Member Ozon?
Yes.
Chairman Bell?
Yes. Okay. Motion carried. Next finding, please. Next motion, please.
Motion for final judgment?
It's the 3B part of that one you just read.
Yes. I move the board issue its final judgment assessing fine and imposing liens relating to the defendant, James D. Houck, based upon the findings of fact issued this date, and that the judgment contained the following provision. Defendant is assessed and ordered to pay a fine of $200 per day for the violation of all violations therein. The fine shall commence when the violation occurred.
November 9th. Or no,
2018, and shall continue until the code violations have been corrected to the written satisfaction of the code enforcement officer.
okay, motion by Sandra, second, or I need a second, please.
Second.
Second. Motion by Sandra, second by Ed. Any questions?
Yeah, I disagree on the amount of the fine.
Okay.
I think the fine is too high.
Tell Sandra.
Same,
See if she wants to amend it.
Now, I have some sympathy for Mr. Hawk,
I understand.
So do I.
Tell her
but
what
he
you want.
isn't, but he's in, and yes, he's in violation.
I'm not asking that. Tell her what you think the fine should be.
Well, I'm not sure what the fine should be, but I don't think it should be $200 per day.
You got from 50 to 250. Pick a
Okay,
number.
50.
I'd be in
Yeah,
agreement
that's
with that.
how
I was
many
thinking,
days?
I was thinking.
From November
somewhere
9th to the,
between 50 and
from
75
November 9th.
myself.
I'm sorry?
I'd be in agreement, I'm sorry? I'd be in agreement with that. I was thinking between 50 and 75 myself. I was gonna take it before you took it.
Okay, Ms. Attorney, how would I correct?
Just amend your,
If you want to amend it, you can amend it and.
I'll be happy to amend it, yes.
You don't have to.
No,
If
I
you
don't,
wanna go with that
I
amount,
think
you
that would
can.
be fine. I
The
just
board
want to
just
make
vote
sure
on
we
it,
get
that's
this
all.
wrapped up today because we need to stop this continuance. $50 is
So
my
you
amendment.
are amending your motion, instead of $200 a day, to assess
$50 per day.
$50 per day.
okay,
My second still stands.
all right. Roll call vote, please.
Member Herman?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
No.
Chairman Bell?
Yes. Motion carried. You'll be receiving a letter from our attorney regarding the compliance issue and the fine commencing starting November 10th, actually, since you're supposed to be done by November 9th, commencing November 10th.
Ladies and gentlemen, I thank you. What you have is a job that is impossible. Attorneys are real good at the letter of the law, and they're good at protecting the law, but they ain't worth a dang at solving problems.
All right, I think this case is over, right?
And I thank you for your consideration. It will be down as quickly as I can. I appreciate your afternoon.
Thank you.
Mr.
Mr. Hopper,
Thank
do you
you.
intend to stay for the second case on the agenda that you're related to?
Is there a second?
There is.
Oh.
There's a second case listed on the agenda, new case number 18-146. If the chair would like me to fast-track
Please.
this case to
Please
this
fast-track it.
time, I could have that case heard now instead of at the end of the agenda.
All right, that'd be a good idea. Okay.
Technology might take 1 second.
All right.
Or a minute if you'll give us a moment to get that pulled up.
Just for a moment here, put your laptop.
Let's go on.
I'm waiting on them. Okay, y'all ready?
Yes, are you?
Yeah, we're ready, waiting on
Okay.
you.
So this is a case of new business. We are looking at case number 18-146 on your agenda. I have Officer Lewis here to provide testimony regarding the nature of this case. Officer Lewis is presenting 20 North Washington. Can you describe the violation at this property, sir?
Yes, the violation is 6-109, specifically 301.3 of the International Property Maintenance Code, vacant structure and land. This is a vacant commercial structure that is in a state of blight. It has several issues there. It's been empty for quite some time.
All right, next slide. Trying to get this to work. Let's see here.
Technology.
All right, Officer Lewis, did you have an opportunity to inspect the premises at 20 North Washington?
Yes, I did. The initial inspection was performed on January the 18th, 2018. Notice of violation was posted on the property. We sent certified mail to the property owner on January the 19th, which was returned. We had notice of hearing sent on October the 10th, 2018 by certified mail and posted at City Hall. Certified mail was returned on 10/22/18.
Before you go any further, sir, do you have the proof of mailing an affidavit attesting to the notice?
Yes, I do.
Can you submit that into the evidence as exhibit number 1?
So it's US mail as well, right? Certified and US mail?
Correct. Yes, ma'am.
Describing the nature of the violation. On the slide before you, you see that the property is in violation, has been cited in violation of the International Property Maintenance Code which is listed under Code Section 6-109. And the applicable section states under 301.3 that this property is a vacant structure and land, and that description of that code section is also before you.
Photographs. This photograph, interior of the structure, you can see there's some moisture on the floor. I can't actually see the roof itself, but from the condition of the interior of the building, it's pretty evident it's getting a lot of moisture in there. I strongly suspect there's several holes up in the roof. More evidence right there where you can actually see part of the ceiling falling in.
Is the date stamp on the slide the date that photograph was taken?
Yes, it was, January the 18th, 2018.
And what does this photograph depict?
This photograph here is also taken on January 18th, 2018, I believe is part of the actual roof covering that was blown off the top of it during the hurricane. This is a photograph of the outside, the structure. You'll notice the soffit, the overhang. They're missing the panels out of it. This is the facade at the front of the building, where the end of it is taken out, been blown out or knocked out one. And that is a picture of the actual notice of violation on the left door there, taken on January the 18th. That is notice of hearing posted on the property on, I can't read it, August the 30th, 2018. And this was a picture last Friday of the structure. See, there's been no change in it.
After your most recent inspection, sir, do these violations all still exist?
They do.
And what is your recommendation relating to this case?
My recommendation is to find that the property is in violation of Section -6109, 301.3 vacant structures and land. And we need to order the respondent to correct the violation on or before December 7th, 2018, and obtain a permit to either repair or demolish the structure. And if he does not comply with the order, we ask for a fine of $250 per day to be incurred.
The first exhibit that I submitted to the Code Enforcement Board, just to be clear, I specifically listed the notice of hearing and complaint as the notice of violation. However, the notice of hearing and complaint was also provided. Sorry for not speaking at the microphone. And then lastly, I also have a cost recovery statement that is referenced on this slide that I'd like to provide into evidence. And Officer Lewis, what is the amount that's provided on the cost recovery statement relating to this case?
$98.05.
Okay.
We also asked for that.
Does the board have any questions of staff before we allow the respondent an opportunity to speak to you all?
I have a question. Is this property does it represent a danger to the public?
The property right now is secure, so I don't think it's an immediate danger. It is secured at this time.
There used to be a bait shop, if I'm correct, right? Or you don't recall?
I think at one time, yes, sir, it had.
Okay. Thought I'd been there a few times.
It was a Royal Castle 50 years ago. Royal Castle hamburgers.
Really?
Mm-hmm.
That's a bait shop.
It turned into a bait shop and a bus station.
Yeah.
Oh, yeah, that's right. Once bus station.
Are there any further questions of staff at this time? Okay, thank you. We'll turn it over to the owner to allow him an opportunity to address the board.
I apologize, ladies and gentlemen, I don't like wasting your time. As you saw, the certified mail was not delivered. I don't have anything save a notice, and the notice had the April hearing information attached to it on the billboard. So I was here to address the billboard, not the building. And I have a picture of the building today, not in January, because I did have some work done on it. That goes with that. If you would, I don't know how to get it to your visibilities, but other than that, I don't really have anything that I can say as a defense or what I'm doing or anything. Don't do that now. Come here. Can this be, come here, Betty. Technology. I don't know how to get that to you.
Does the city have any objection if he just passes his phone?
I have no objection to him sharing it by physical delivery.
When did the city take the photos that they had? I'll take it, sir. The photos that the city had, when were they taken?
It'll go goofy.
They were 1/18
It's pretty
and then
touchy.
11/7/18.
There you
The
go.
most recent was 11/7/18.
Oh, a couple of days ago.
Yes, sir. Our picture was from the 7th.
That was taken, 12 o'clock-ish today. I don't know why the certifieds weren't delivered.
The same address? Your address
Yes, ma'am.
correct?
I got all the other communications from the police and from you all.
And who's Bo Davidson? Does he work for you?
Bo Davidson used to work with me, yes.
Well, somebody talked with him, so.
Well, if he'd have signed for him, they wouldn't have rejected him.
Turn on the camera.
How did I do that?
Yeah.
Oh, wait a minute, there it is.
Got it?
I don't know. All I do is touch it and it goes haywire. Well, that's a little bit better than what it did.
I don't know, if we could look at the same.
I believe the image that's on your screen is from the rear.
Yeah.
And
Yes.
what we saw was the front view.
Correct. It's the rear and the side. It shows that the shrubbery is trimmed on the west side, the left side in front of the truck. It's being maintained. There's no trash in the lot.
Can we go back and look at the pictures that we have?
I think,
Mm-hmm.
Yes, once the owner's done, we can ask for the, there it is, that.
There it is. And here is the mailing, if that is cogent to the situation with the complaint. And notice of hearing for today. And the attachment is all of the information from the April meeting on the sign.
Which pictures did you want to display?
I wanted to look at him, not him, me.
Which ones did you want to see?
This is fine.
This one? I'll let you use the clicker if you'd like.
No, that's okay. All right, I just, yeah, okay.
Well, the majority of the pictures were taken in January. Why did it wait so long for this to come before the board?
We were working. I can't answer.
January to November is 10 months.
That's correct. I can't answer. I haven't had conversations with them. Officer Lewis has had conversations with representatives, so I don't know.
picture, the picture we're looking at here was actually taken on, okay, the 7th of this month, am I correct? And we were looking at the junk and debris also?
No.
I don't see any.
Junk debris is not on there.
We didn't cite junk debris or.
It's vacant
Okay,
structure.
all right, okay, making sure. You know, if we could see, if you had pictures of the roof, we might be able to say, okay, you may be right, but we don't see, all we see is exterior pictures here. It looks like some work may have been done along the eaves, if you want, for lack of a better term.
There is a mural along the east side. The west side has got a tree and some shrubbery that has been trimmed and maintained per my picture. The mural on the side is still quite serviceable and not ugly. The hurricane did do some damage, and I have been talking with a realtor to try to figure out what we can do with that, a broker, because there is a 50-foot setback. And there's not enough property there to do something with according to the building restrictions in Titusville. So I could have brought him, but I did not, to verify that. We think a Waffle House may fit there, but they're still looking at the footprint, I guess is to say, to see if there's enough parking around, enough room to do that. If there's enough there to go to war with the city to fight the setbacks and try to get a footprint.
You've pulled any permits on this property?
I have not.
Not for any repair work or anything, inside or outside?
I have done some repair work, otherwise it would not have looked like this, because Irma came through in October, and the picture I showed you today showed there's no debris, no trash in the lot.
And the building is secure, including the windows.
The building is locked up, there's no power to it, there is some mansard hanging, yes, and I mean to get anybody in trouble, but after the April meeting, there was a conversation, a brief conversation that because I had brought it up in April meeting to try to look at the whole property, the billboard and the building, to get a time frame and a plan to do something with it. After the meeting, on my way out, I was addressed by a building official that said it may not be prudent for you to do anything with that preemptively because of demolition and asbestos and who knows what all in there unless you have a direction for it. So that's what I hung my hat on, is that I don't have a direction, but I'm looking for one.
I'd like to have an opportunity to respond when he's done.
Anything else? Anything else?
No, ma'am, I don't think
Okay.
so.
You just have a seat. All right.
If I may, please invite the building official to the podium. Mr. Stepalovich, do you recall having any such conversation with any owner of any property advising them not to apply for a demolition permit?
No, I have
as
not.
described? So the comments that were just made are currently being refuted by the building official as he disagrees with the comment as something he would have or could have said, because, do you have a reason why you would not have said?
It's not my place to make comment like that to any customer.
And I would like to also invite up the Code Enforcement Inspector, Officer Lewis, to provide additional testimony. Officer Lewis, did you have any conversations with the owner's employees regarding this property?
Yes, I did. Early on in the case, I had a conversation with a gentleman by the name of Bo Davidson that claimed to represent the company. At the time, I advised him, before you've done anything, which I would have done with any owner, is to check with development services and the building officials before you do anything to see about a permit or a demolition permit. In all fairness, if they'd have went and just tore the building down, they may not have been able to put the building back. So it's also my responsibility to advise him of that. I think Mr. Hawk is confusing me and Mr. Stepelofich after the April meeting. I do remember speaking with him some. I don't exactly remember what we discussed, but I did speak to this gentleman, Mr. Davidson. I don't know if he's still in his employ or not.
Would Mr. Hawk need building permit to do the repairs that he said he's already made?
Yes, he would.
So let me understand that you admit that you may have told Mr. Hawk if he takes a building down, he cannot replace it with any other building.
I told, not Mr. Hawk, I remember telling his representative
Okay,
that he needs
okay.
to check on that before they do.
Okay.
Are there any other questions of staff regarding this case?
I have a question. The inside of the building is in bad shape. The roof is in bad shape. Is the blight, the word blight, I mean, I haven't seen that used in cases previously, so just curious about that, you know, exactly, are we talking about just superficial appearance? Are we talking about just trying to get a grasp on?
Both the overall condition of the building is contributing to the blight because it's causing the building to deteriorate more and more.
Right. Thank you.
All right, thank you, officer. No further comment at this time.
All right, what do y'all want to do? That'd be the first
Madam
reading.
Chairman, I'm ready to make a motion on this case, please.
Okay.
Okay, motion for initial finding of the fact. I move that the board issue the following finding of the fact on case number 18-46 relating to the defendant, James D., does it say Howe? Howe. The defendant was properly notified of the violation as alleged in the complaint. The defendant is the owner or in possession of the real property located at 20 North Washington Avenue, Titusville, Florida. The defendant is in violation of the following provisions of the Code of Ordinance of the City of Titusville. Section 6-109, property maintenance, subsection 301.3, vacant structure and land.
Second.
Motion by Ed, a second by Gina. Any questions? Roll call vote, please.
Member Ozon?
Yes.
Member Richardson?
I'll vote no on this case until I have some further information.
Member Herman?
Yes.
No, Herman. Mr. Herman.
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
I have some reservations.
Yes or no? No reservation.
No.
Member Monis?
Yes.
Chairman Bell?
Yes. Motion carried. Next motion, please.
I move that the board issue its order to correct relating to the defendant, James D. Howe, adjudging the defendant to be in violation of the section of Code of Ordinance of the City of Titusville as determining in the finding of the fact, giving the defendant until 12 noon on December the 10th to correct the violations to written satisfaction of the code enforcement officer or to appear before the board at City Hall, Titusville, Florida, on December the 10th?
Yeah, December, go to January. December won't be here. January.
We're not doing December 10th.
No.
We're not.
We're not.
Okay, what was the January date?
January.
We don't have the calendar up.
Wait a minute. January 8th. January 8th.
Okay, January,
January 8th.
Okay,
2019.
January the 8th, to show cause why the violation has not been corrected and why this board should not proceed to impose fines for the violation. Should the first one, the defendant, having 12 noon on January the 8th also?
January
Yeah, it's going to
14th.
be January 14th. I'm sorry, I made a mistake. It's January 14th. Be January 14th, 2019.
January 14th, okay.
You want to move your compliance date?
Yes, ma'am. Okay, we'll amend that to that date. The defendant is ordered to pay $98.05, which represents the cost incurred by the city of Titusville to bring this case before the board. Where would the new procedure of the possible fine would be starting off at $50 per
We're not-
day? Would that be a proper place?
But we're not there yet. We're not at that point.
We're
This is
not.
just the first reading. You're not at a...
Okay, just the
this is
first reading.
Okay, but it sounds like he
Oh,
wants to follow
okay,
the procedure
okay,
that-
all right, okay. Sorry, I
And
forgot about
then
that.
you would say, if not in compliance by January 14, 2019, then a fine shall be imposed in the amount of,
$50 per day.
for each and every day the violation continues past the January 14, 2019 date.
Okay, can you make it show on the,
Is that?
your wording?
My wording, is that
Your
acceptable
wording
to
would be
you?
acceptable with me,
Your
yes.
motion.
What was the compliance day, Ed?
He changed it to the January 8th.
Okay.
Or January 14th, whatever the day.
Yeah,
And the meeting, and then, okay. So
okay.
they think we on the 14th.
Two
okay.
January dates.
All right. Any questions?
Yeah.
I mean,
Well, I'll
okay, wait a minute.
second it.
Y'all got me confused now.
I'll second it.
Okay. Gina.
Okay.
I have a
All right.
question,
Right, go ahead.
or comment. I believe in this case, you're asking him to improve it, to bring it up to compliance, when in fact, it may be undevelopable. I would be in favor of giving him time to contact the building department and determine if it's developable.
Well, he's got 2 months.
If he can even put a building on that site. It's not adequate parking, they said. So,
This is shoulda, coulda, woulda. It's not for us to determine that at this time. We'll just move on
well,
and,
it's a case of reasonableness, to me.
you're entitled to your opinion.
And you are yours.
I'm going to read what the statute says. Okay, it's for 303.1 for vacant land, structures and land. It says vacant structures and premises thereof or vacant land shall be maintained in a clean, safe, secure, and sanitary condition as provided herein so as not to cause a blighting problem or adversely affect the public health or safety. So there's nothing that's saying that he can't bring it to a clean, safe, secure, sanitary condition.
He is-
Even if he can't rebuild, the property there itself can be brought to a clean, safe, sanitary condition.
And I asked earlier,
I
and
guess
when,
what a
in
blight,
this
to
whole
define
discussion,
blight.
is this property a danger to the public? And it is not. So it can be made more presentable.
I think the buzzword here is blight. What's your definition of blight? And say blight can be cleaned up. Okay.
Well, the
Convince me of
question
that.
I asked early, right at the beginning was, is this a danger to anybody?
Yeah.
And I was told it was not.
How can you remove,
I'm with you on the blight. I don't even really understand.
So you have a motion on the
Are we
floor and
voting
a
yet?
second.
We've got a motion by Ed, a second by Gina. And the question, did you have a question or just a comment? Joe,
No,
question, just a
don't
comment?
have either one.
Roll call vote, please.
Member Richardson?
No.
Member Herman?
Yes.
Vice Chairman Beckles?
Yes?
Member Grant?
no.
Member Monis?
Yes.
Member Ozon?
No.
Chairman Bell?
Yes. All right, we have a, it was in favor of, motion.
4-3.
Yep. Okay, you'll be getting a letter from our attorney in regards to what the violation is and what you need to do between now and the 14th of January of next year.
Can I
And you
have a
should
minute,
talk
or
to,
can I get it
but you
added to
should
the
also
agenda?
talk to the code enforcement officer, and he can explain what he deems that you need to do to bring it up to code.
I appreciate that, and that will happen. I would like just a minute.
You've got to get up to the microphone.
I would like a minute with the board, or I can get on the agenda at the end. Your pleasure. That's all I was trying to say.
That's not a doable. No, that's not doable. Not under the rules of what we have to do for it. Talk to Mr. Tolson or talk to the city attorney. But it'll have to be after we're finished. This has been a All right, Chelsea, next case, please.
All right, going back into old business on your agenda, the next case listed is number 18-116. The city has identified in your agenda that compliance was achieved on October 25th, 2018 for the property located at 585 Birchwood Lane by reason of active water is provided to the property. That violation does not continue, and I would like a motion to close this case.
Se-
Okay.
Should we go through the,
Are there any questions?
Any questions? Roll call vote, please.
Wait a second.
Wait a minute.
Can I ask one question? Sorry.
Are you asking the board to go ahead and enter an order finding them in compliance and the case being closed?
Yes, ma'am.
Okay.
Roll call.
May I ask who the second was?
Joe?
Okay. Vice Chairman Beckles? Yes. Member Herman?
Yes.
No.
Herman.
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 Yes.
Member Monis?
Is that me?
Yes, you-
me.
Member? Yes? Okay. Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
shouldn't this motion been read into the records?
Yes.
But it wasn't. Someone just said,
So moved.
so moved. Is that legal? You didn't cite a case number as the.
Okay, all right, stop. Start all over. Ed, give me another, finishing the compliance with the case number. This is getting ridiculous.
No, if it's not,
Ed?
Yeah, I'm just bringing that up. Okay. Motion for final compliance with,
Case number?
I move that the board issue this order finding compliance in case number 18-16, 116, finding the defendant, Harry M. Meach Trust, in compliance with prior decision of this board to issue this case and closing this proceedings
As of 10:25.
as of 10:25.
second.
Motion by Ed, a second by Joe for the compliance of case number 18-116. Roll call vote, please.
Vice Chairman Beckles?
Yes, again.
Member Herman?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Bell?
Yes, motion carried. Case closed. Next case, please.
The next case on your agenda is number 18-117 for the property located at 2225 Monticello Court. The code officer who initiated this case was Bob Crisco. It was handed over to Officer Lewis. And I have also invited the customer service manager, Carrie Beatty, to the room to provide testimony regarding this case. I'd like to first invite Officer Lewis to present the PowerPoint, and I will invite Carrie up after some initial evidence is presented to you. Officer Lewis? This case was previously continued twice, so this is new business for you. This is the first time you are hearing this matter. Officer Lewis, tell us about this case.
Respondent, property owners Bobby R. and Brenda Wynn and Larry McMillan. The violation address is 2225 Monticello Court here in Titusville. We mailed the notice to the same address at Monticello Court. Violation is section 6-109-102.2, occupied with no active water source. The codes, that section of the code specifically prohibits disconnection of any required utilities for the structures for an occupied dwelling, and also that if it's not, even if the tenant fails to do it, it would be the owner's responsibility to have that done. In this case, this is an owner-occupied dwelling.
Going back in this case, when was the notice of violation given to the owner of record, and do you have a copy of that with you?
Yes.
Do you have? Okay. Sorry.
The initial inspection was on May the 18th, 2018, when the notice of violation posted on property. On 5/23/2018, certified mail was sent to the address and signed for and returned on 6/4/18 from the owner.
Please submit the proof of mailing and affidavit as to notice into evidence, just these two sheets, as exhibit number 1. After Officer Crisco's initial inspection, did you follow up and give the property an inspection, or are any of these inspections yours, or are they all from the prior inspector? The follow-up inspections, those dates that are listed here.
There would be follow-up inspections from the prior inspector, except the one on 11/1/18 would have been me.
Okay, so the record is clear. Officer Crisco initiated this case, and Officer Lewis took it over, and his follow-up inspection was performed on November 1st, 2018. Did you find that the property was occupied?
Yes, I did.
And does the code enforcement file have a record of the notice of hearing and complaint being issued to the owner of record?
Yes.
Can you please submit that into evidence as exhibit number 2? This goes with it. This slide here goes over the city code defined. Officer Lewis has indicated that this property is occupied in violation of subsection 102.2 of the International Property Maintenance Code, which requires that any occupied dwelling have active water service. Initial photo was taken by the initial officer on the case, as demonstrated above. Officer Lewis, can you describe what these photographs depict?
This is the initial compliance date when the property should have been brought into compliance. On June 18th, 2018, you see 2 vehicles there. So it's obvious the property is still being occupied. And there's your notice of hearing posted on the property on August the 29th, 2018.
And what is the code board's recommendation, or code enforcement department's recommendation?
The recommendation is that the respondents Bobby R. and Brenda Wynn and Larry McMillan, owners of record of the property at 2225 Monticello Court, in possession of control of the property in violation of Titusville Code of Ordinances, Section 6-109, International Property Maintenance Code, Section 102.2 as defined. Order respondents to correct the violation on or before December the 7th, 2018. In order to correct it, they either vacate the property or establish and approve active water source to the property. Order the respondents to be assessed administrative costs in the amount of $150.88. And if not do not comply with the order, then a fine of $150 per day be imposed for violation. I'm sorry.
That's not correct.
There is a mistake in this slide. The city's practice for this type of violation is to ask for zero fine and to only impose the cost of bringing the case before the board for a property that is in violation of being occupied with no active water source. So that is a mistake on the slide presented in front of you. Officer Lewis, do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
Yes, I do.
And what is the amount?
$150.88.
Please submit that into evidence as exhibit number 3.
Where did you get it? Where'd you get it about each day? It's not up there.
I'm sorry, I didn't read the part that says in lieu of a daily fine. That is a correct statement. The fine would be 0, the cost would be imposed as the only amount that the city is asking for recovery in just that base amount. And that has been our practice with this. I'm open to discussion with the board attorney if you have a comment on this. I also have testimony to provide from the customer service manager that I'd like to do before we discuss that. Officer Lewis, do you have anything further to add on this case? Ms. Beatty?
I have a question. Are the windows boarded up on that house?
My question too.
There's 2 windows in the front boarded. Why, I do not know. The day I was there on my inspection, there was 2 vehicles there, plus a trailer in the side yard with some landscaping equipment on it. The truck that was parked there, the windows was rolled down. The house is still occupied. I don't know why the windows are boarded.
Thanks. Thank you. Ms. Nutcher?
I'm just looking at the exhibits, Exhibit 2. I have the notice of hearing, the affidavit, and the complaint, but I only have the notice of hearing for the September board meeting. I don't have the notice of hearing for the November board meeting.
I have in my hands the order continuing the case, where the case was originally scheduled for September and continued to October, and then it was scheduled for October and continued to November, if you'd like to see them both.
Okay, so the order continuing has the right date for the hearing, for today's hearing?
The second one, sure, yeah, November 12th.
Okay. Do you wish to put these into evidence as well?
Sure.
To confirm that
Sure.
notice was provided for today's date?
Yes.
Okay. I'm gonna, let's make that Exhibit 4 then.
That's fine. Carrie's coming up. Ms. Beatty, if you'd join me, please. I have invited Ms. Carrie Beatty, a utility the utility customer service manager for the city of Titusville, to provide testimony regarding the property located at 2225 Monticello Court. I'm going to go through some questions that I have asked this department over these types of cases in the past, and to refresh the memory of the Code Enforcement Board and to inform the Code Board attorney about this process. Ms. Beatty, do you monitor the collection of delinquent customer service accounts for water service provided by the city of Titusville?
Yes, I do.
And upon the termination of water service, how does the city investigate the occupancy of each property?
Can you repeat that again?
Yes.
I'm sorry.
Upon the termination of water service at a property, how does the city investigate the occupancy of each property?
We contact both. If it's a tenant account, we'll reach out to both the tenant and the owner in regards to the termination of the water service to find out if anything has occurred, like they may be, you know, in the hospital, something like that. And we try and work with them in regards to getting the service back on and reconnected.
And upon the termination of water service, such as at this address, has the property owner been contacted by the city of Titusville for this particular address, 2225 Monticello Court?
Yes.
And generally, how can a violation of subsection 102.2, a property that's occupied with water service, how can that be corrected?
Have the water service reconnected or vacate the property.
If you didn't hear, she said vacate or turn the water on at that location. And so with this property, did you verify that the property located at 2225 Monticello Court, which is listed in today's code enforcement agenda, does that property have a balance remaining in that that has demanded that the water service has not been reestablished since it was last connected to this site?
Yes, they do have a balance.
What is the amount that's past due on the account?
The current balance is $1,519.48.
When was the account cut off from service?
The account was originally cut off on March 28th of 2018.
Has there been any indication of consumption on the account since the account was turned off?
Yes, there has.
Has the meter been pulled?
Yes, it was pulled on May 29th of 2018.
And has there been any communication with the account holder since that time?
According to our notes, we did discuss the situation with the owner of the property on August 31st, 2018. He had came in to find out the balance and stated that he would pay it in full on September 28, 2018. And prior to that, we did find straight piping. So there was additional meter tampering, and there was a $100 charge added.
Your mic.
What day did you say you talked to the owner, the property owner, occupant, whatever?
We talked to him, sorry, just get my page back.
August 31st.
August 31st.
When was the last payment received on this account?
Last payment was received on September 28th of 2018,
In what amount?
$200.
Did you, 200?
What was the date again?
September 28th, 2018.
Okay.
And prior to that, what was the most recent payment?
September 27th, we received a $1,000 payment.
And prior to that? If you don't have that record because it goes back too far, that's fine. The point that I am making is that the owner was working with the city to establish reconnection by paying the necessary amounts, and they knew what process was required in order to reconnect that water service. The issue here is that the balance has not been paid to the city's satisfaction in order to reconnect this account. And as you've heard from the code enforcement officer, the property remains occupied, which is why both the case was continued for the past 2 months as progress was being made towards the reconnection. However, at this time, the reconnection has not been made since March 28th, 2018. This property has not had an active water source. And due to the status of this property, the city requests that you make a finding of fact that this property is in violation, unless you have any further questions of staff.
I do. If I heard correctly, they've made $1,200 worth of catch-up payments. And what is remaining? The 1,600?
No, what is remaining is what I had stated prior, the $1,519.48.
So the total bill was about $2,700.
Correct. It was $2,560.61 prior to those payments.
And they tampered with the meter twice.
Correct.
When was the tampering? I mean, in relation to the payments, I mean, what I'm trying to establish is, did they tamper it, and then they decided to try to go ahead and get on the right path and pay?
We found a straight pipe after we had pulled the meter. We pulled the meter on May 29th, and we found the straight pipe on June 12th, 2018. And that's when we ended up pulling the jumper and disconnecting that.
But that's when they started paying, after that?
After that is whenever they came in, discussed it with us to find out what they needed to do to get the water source back on. And we informed them that we would need everything paid.
Right. And so so since that time, now they're working with you to pay, or at least have started paying.
The last payment was not received, there has been no payment received since the end of September.
Right.
And that's 45 days ago approximately.
But the city is willing to forego any fines. Am I correct?
Daily fine.
Daily fines.
That is a discussion that I would like to have with this board after a finding of fact is made.
Very well.
Okay. Well, they're in violation.
I'll do it.
Okay. You want to? All right.
Thank you, Carrie.
Go ahead.
I move that the board issue the following findings of fact in case number 18-117 relating to the defendant Bobby R. Wynn, Brenda Wynn, Larry McMillan. The defendant continues to be in violation of the following sections of the Code of Ordinance of the City of Titusville on November 12th, 2018. Section 6-109, property maintenance, by reason of subsection 102.2, occupied with no active water source.
Second.
I have a motion by Ariel, second. By Joe. Any discussion?
The last question, you haven't heard anything? You haven't heard from them since September, since that last payment on September 28th, nothing? No contact or anything?
Correct.
Okay.
Roll call vote, please.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Herman?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Chairman Bell?
Yes, motion carried. Next motion, please.
I move that the board issue its final judgment assessing fine and imposing a lien relating to the defendant Bobby R. Wynn, Brenda Wynn, Larry McMillan, based upon the findings of facts issued this date, and that the judgment contain the following provisions. Defendant, and I'm somewhat lost on this,
Just,
I'm not sure how to
Just
present this.
okay, just say the violation of the section, and then as per the city code, no daily fine, but due admin cost of whatever it is.
Is that okay?
Well, I thought the city attorney wanted to talk about the fine.
I would like to explain again why we have this protocol for this type of case.
Don't we have to finish the motion out first?
No, because if you're gonna make a motion regarding the fine, then we probably want to resolve the issue of the fine first.
Yeah.
This type of case has been presented to this board in the past, and the issue does revolve around a financial burden on the owner, and there is alternate means to obtain compliance. And so there's different ways of looking at it. However, in the past, the way that this board has viewed these types of cases as that the owner is in a financial position that they will not be motivated by an additional fine. And typically, code enforcement gives motivation to the owner to correct the situation by way of a daily fine. However, with an active water property, then that owner may not be motivated to correct the situation by that punitive fine that would further their situation of not being able to afford the water service at that property. The city's interest in obtaining a final judgment that's recorded on the public record is for multiple reasons. One, to comply with the city's code of ordinances, that's what your DD is, but the city's goal is also to inform the public that may later occupy this property that there's a issue that the occupants are living there without an active water service, which creates hygienic and welfare issues for both that property and the residents there. We would like to resolve the issue by finding of compliance, either having the residents vacate and go somewhere that there is water, or to get the water service turned on by either getting a well or getting in good standing with the city's water department. But with none of those situations presenting themselves today, and as you found, there is a violation in front of you. However, I do not know that a daily fine would motivate any owner to correct this situation. If you would like to discuss with me what your thoughts are, I'm all ears, but that's where this board has gone with this type of case in the past. And I know that Ms. Nutcher gave me an appearance of wanting to discuss, and so I invited the opportunity to discuss at this time.
I just want to ask one question. Does the amounts that are owed include any kind of penalty for late payments?
The water bill does include late payments,
So they're already being penalized?
late charges.
For the late
But the city has
charges?
the ability to negotiate late charges. They won't be firm on that, so I can't guarantee that the late charges will all be paid because they could be removed in the future by the water department. That's outside of this jurisdiction.
My only comment, and then I'll leave it to the board, is everybody says they have financial issues in terms of coming into compliance with codes. So I'm not sure why this one would be a more distinct type of violation. I mean, to me, it seems a pretty serious violation that someone's living there without water. That's unsanitary and unsafe and unhealthy if there's children. So I would think there should be some motivating factor if you bring it before the board. And usually the motivating factor under 162 is the imposition of fines. That's my only comment.
Well, you still charge the owners, what, $35 a month or something, even if the water is off, right? So
The
they're still
city
paying.
code does have an availability charge to every property that has water available to it. Yes, that's the code, that the property will continue to receive a bill for all those charges.
So they're being fined. Okay.
So, okay. So what does the board want to, oh, thank you. You guys want to impose a fine? We're in the middle of a motion here, and I'm not sure what to do about this. You are going to assess the cost recovery, am I correct?
Yes.
That's what they want. We want to assess the cost recovery, but no daily fine.
Well, I know what they want, but I'm asking what the board wants.
This is what we have done, what we have agreed to as board a long time ago when the water department started presenting these cases to us, and it was probably about the best way to handle it is let the city determine how much they're going to pay instead of us hitting them with a fine of $100 a day or $50 a day when they've got a burden on them with the water department as it is. So I think it's probably about the best way to handle it is let the city and the water department do what they can and come up with a reasonable amount in payment or whatever, however they're going to handle it.
To basically negotiate a settlement, right?
I think that's what happens is they negotiate a settlement of some sort, a nominal fee or whatever, however they work it. It's out of our hands. I mean, we can impose a fine on them of $150 a day. If they can't afford to pay $25 a day and
$30 a
working
month.
on that,
Well, the reason why I ask these questions is because I've never seen an issue like this since I've been on the board.
We just started getting these cases, what, about a year ago? And none of us want
About
to
2
deal with
years
them
ago.
because
About 2
we
years ago, no.
basically don't feel it should be our responsibility. The city always did it, and all of a sudden, it was put on us. And all of us kind of disagreed with it, but this is where we are. But I totally don't, I do feel these cases are different from the other cases, despite what the attorney might have said, and I do feel that we should have more compassion with these cases, and that's just my personal opinion.
I don't, I've been on the board for 3 years now, I don't recall this, but I'm not arguing, I'm a gentleman, I'm not arguing. So I have no problems, I just want to make sure the board is.
It's a soft case, it's a soft case for
Okay.
us, with the water department.
Shall I
when they
finish
come
the
in
second
and
part of the
ask.
motion?
Please.
Okay. I move that the board issue its final judgment assessing fine and imposing lien relating to the defendant Barbie R. Wynn, Brenda Wynn, and Larry McMillan, based on the finding of the facts issued this date, and that the judgment contain the following provisions. And where am I? The defendant is assessed in order to pay a fine of $0 per day. And should I add that they will be required to do the cost recovery? Because
Yes.
it's not part of the statement.
Yes.
Okay. So moved.
Second.
The fine No, there's no sense in continuing it because it's done.
Motion by RL, second by Joe. Any questions? Roll call vote, please.
Member Richardson?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Chairman Bell?
Yes, motion carried. Next case, please.
Yes. The next and last case to be heard is listed under new cases for case number 18-144 for the property located at 124 Bermuda Street. Officer Ashley Tuggle is here to provide testimony regarding her case.
Okay, it's case number 18144. The respondent is David Timothy Ford. The address is 124 Bermuda Street, which is also where the mail goes. The violation is 13-26 overgrowth. I initially inspected the property on July 16th of this year. He was mailed the notice on the 17th, which I have the affidavit attesting to that.
And she'll submit that into evidence as exhibit number 1.
And then I posted the notice of hearing on October 8th of 2018, which I have the affidavit for that. Exhibit number 2? Okay, as exhibit number 2.
Thanks.
Originally, he was given until the 26th of July to comply. I spoke to him, or actually he left a voicemail on the 26th and asked for an extension. When I called him back to talk to him, his voicemail box wasn't set up, so I wasn't able to leave a message, and I have had no contact with him since then. I conducted multiple re-inspections, and as of this morning, the property is still overgrown. The specific part of 13-26 that it's in violation of is grass in excess of 12 inches in height from the ground. This is the front yard, which the front yard wasn't too bad, but you can see the backyard is where it's extremely overgrown. That's more of the front of the house. When I went back on the 26th, he had mowed this one section on the side of the house, but nothing else. And it's now back to being overgrown. And that was on the 18th of September. This is again on the 18th of September. This is where I posted the notice of hearing on October 30th. And this is a photograph of the property as of 11/7. And I went out this morning to make sure that it wasn't in compliance, and it is not still.
You weren't able to get photographs of the backyard?
Not any closer than from the yard
Okay.
or the roadway. Based on the testimony and evidence presented in 18144, it is determined that the respondent, David Timothy Ford, is the owner of record of property located at 124 Bermuda Street, located in Titusville, Florida, as determined by the property appraiser records, in possession or control of the property in violation of Titusville City Ordinance Section 13-26 as defined. It is further recommended that the Code Enforcement Board order the respondent to correct the violation on or before 12/6/2018. In order to correct the violation, the respondent must remove all overgrowth from the property. Order the respondent to be assessed administrative cost in the amount of $168.49, which I have the cost recovery statement as Exhibit 3. If the respondent does not comply by 12/6/2018, a fine of $50 per violation per day should be imposed for each of the violations that continue. Any questions?
Have you ever seen them out there?
I have not seen anybody there. There's been a car there multiple times, but no one's ever contacted me besides that one first phone call.
Pretty straightforward. Any more questions? We have it.
Look at it.
We have it, you don't. There you go.
This one or the one before it?
That one. Bless you. Any questions? I need a motion I need a motion.
Okay. This is the first,
Yep,
first
the
time,
first
right?
reading.
Yeah. I move that the board issue the following finding of the fact in case number 18-144 relating to the defendant David Timothy Ford. The defendant was properly notified of the violation as alleged in the complaint, and the defendant is the owner or in possession of the real property located at 124 Bermuda Street, Titusville, Florida. The defendant is in violation of the following provisions of the Code of Ordinance of the City of Titusville, Section 13-126, by means of overgrowth.
26, 13-26.
I'm sorry, 13-26, by means of overgrowth.
Second. Gina was first. All right, got a motion by Ed, second by Gina. Any questions? Roll call vote, please.
Member Herman?
Yes.
Vice Chairman Buckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Chairman Bell?
Yes. Next motion, please.
I move that the board issue. Nope, sorry. I move that the board issue its order to correct relating to the defendant David Timothy Ford, adjudging the defendant to be in violation of the section of Code of Ordinances of the City of Titusville as determined in the finding of the fact, giving the defendant until 12 noon on November the 30th, November the 30th, 2018, to correct the violation to written satisfaction or, written satisfaction of the code enforcement officer, or to appear before the board in the city of Titusville, Florida. We're using the January the 14th date?
Correct.
On January the 14th, 2018, to show cause why the
2019.
violation has not been corrected and why this board should not proceed to impose a fine for the violation. The defendant is ordered to pay $168.49, which represents the cost incurred by the city of Titusville to bring this case before the board.
If compliance is
And
not
also
made,
the
wait a minute,
fine.
if compliance is not made, what? Compliance is not made by November 30th.
I'm sorry. Yeah. If compliance is not made by
November 30th.
November 30th, the fine of $150 per day will be imposed upon them.
Look at what your violation, look on your screen, what they're saying. They're saying the city's asking.
Yes, I realize that that's what they asked for, but I don't agree with that charge if that's okay with the city.
Okay, so 150?
$150 a day.
Okay, motion's been made, need a second.
I think $150 a day is excessive in relation to what we normally charge for overgrowth. I'd be satisfied with what the city suggested at $50 a day.
I could.
How's the rest of the board feel?
I think $50 a day is a fine. $50 a day is,
Especially since
My
they have
opinion.
such a short window of time to get the compliance.
Okay, I'll amend it to $50 a day.
I need a second.
Second.
Who is it, Mr. Herman? All right, motion by Ed, second by Mr. Herman. Any questions? Roll call vote, please.
Vice Chairman Beckles?
Yes.
Member Herman?
Here, yes.
Member Monis?
Yes.
Member Ozon?
yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Bell?
Yes. Motion carried. Board Attorney's report? None? Okay. City Attorney,
None.
Code Enforcement Managers?
Yes, ma'am, if I could, just real quickly, we've canceled the December meeting as, actually, we had an opportunity to get all the inspectors to a training for assessment in the event of natural disasters, and it's only offered twice and usually out west, so we want to take advantage of it. Unfortunately, it was on Code Board Day, so I hope y'all are okay with taking the month off.
That's fine. All right.
And actually, I just wanted to share with the board, as I was looking through the monthly reports, this month, knowing that we were down one, we were still able to close 547 cases with compliance before the first reinspection. And I think that was quite a tribute to the 3 inspectors. They were really working hard this month.
Good for them. Thank you very much. We appreciate
Other than that, no other report, ma'am.
Okay. Chairman's report. It's been asked, Ms. Nusher, if we could have another meeting sometime after the first of the year to go over fines and some of this other stuff today, from today.
Okay.
It'll be after, sometime, we'll figure out a date after the first of the year. Is
Kind
that
of like what we did, I did
okay?
today?
Yeah, kind of like we did
An
today.
hour before the
Yeah,
meeting?
about an hour before the meeting.
Okay.
We'll give you more details next year.
Well, Ms. Ozon was more specific about what she wanted.
Well, yeah, I would just interactive questions.
Yeah.
That we would have.
That's fine.
Okay, so we'll plan for that after the first of the year.
And you all, Madam Chair, you want me to revise the motions?
Yes, please.
If I could get a copy, Megan, if I could get, oh, okay. This isn't on like Word or anything, is it?
I believe that Rick Rogers had prepared it to the board members, so I don't have an electronic copy, but
That's
we can
fine.
certainly make a copy and get one to you.
I can have my assistant do it. I'll have my assistant do it. That's fine.
If you'd like.
We'll have that typed and sent to you.
Okay, that's fine. Thank you.
Okay, anything else? What about this gentleman, Mr. Hawk?
Chairwoman, that's your decision to invite him to the podium.
I can give you 5 minutes.
I won't take that long.
All right.
Y'all have had a long afternoon. This is, I'm 70, and I think if I need to do something to make this world better, that's what I'm trying to do.
Okay.
From this side of the podium, I needed a little more communication. You saw the certifieds got returned. I didn't know they were there. Look in my file and see how many certifieds I have responded to. I didn't know they were there. Who said the guy put a note in my mailbox and it didn't get blown out, or he didn't put one in there? I heard that the residentials made a call. Maybe that needs to follow up. That's number one. Number two, the signature blocks on the legal stuff are signature.
Is this stuff relative to the case? We have a protocol that we kind of follow, but if you have more testimony or something relative to the case?
No, ma'am, these are recommendations on
We
how
don't
you
need, we don't
become.
need general recommendations.
Well, then do I need to refer
you
me
can
to
talk.
somebody? That's what I'm saying.
want
Communication
to-
from our end.
Talk to the manager, or talk to the inspector. Okay? Thank you.
Sorry to.
Megan, prior to, before now, the 1st of December, can we have new 2019 calendars, please? Thank you. All right, any questions, comments, concerns?
Happy Thanksgiving.
Well, that's what I was gonna bring up
Merry
next.
Christmas and Happy New Year.
All right, thank you. We'll see you next year. Thank you very much.